We've been talking a lot about property landlords, property education, and the pressures, if you like, on landlords to get things right, to be professional, because we are responsible for the health and safety of the families that live in our lives. And in this podcast, I've got the brilliant Julie Ford back again, and she's going to explain how when it goes wrong, it can really go wrong. You know, there are 169 acts, and I think she said 402 regulations. We very definitely need to be professional. So please listen to this episode, have your pen and paper ready, and learn loads from Julie Ford.
Hello and welcome back. This is part 2 of my conversation with the wonderful Julie Ford. If you listened last week, you'll have heard her 5 really common sense yet slightly earth-shattering top tips for protecting your rent and how to deal with rent arrears. And just at the end of that conversation, we were getting into the one-liner there that was around, and of course, if it does end up as eviction and you haven't protected your deposit properly, then you're going to be in big trouble. And Julie pointed out that bombshell about the multiplying deposit fee cost penalty. Do you want to pick up from there, Julie?
Yeah, absolutely. So I think this is one of the things that I'm still surprised about every time I'm contacted by a landlord or letting agent who has a tenancy deposit claim against them. So it's been law since 2007 to protect the tenant's deposit into one of the 3 government schemes. And it still surprises me today that there are landlords and letting agents out there that still don't know they have to do this. Now, it used to be that you had to protect it within 14 days of receiving the deposit. And then with the Deregulation Act of 2015, that moved to 30 days. So basically what that means is when your tenant pays a security deposit, not the holding deposit or the first month's rent, your actual security deposit, you have to protect that in one of the 3 schemes within 30 days of receiving it and issue the tenant what's called prescribed information, which is exactly what it says. It's a prescribed document, so you can't make it up yourself. It's produced by the deposit schemes, and you have to give that to the tenant within the 30 days as well. Failing to do either of those 2 things gives the tenant the right to come after you for a maximum of 3 times the value of the deposit for each tenancy that the deposit remained unprotected for. So, for example, if you've got 6-month tenancies and you're renewing tenancies every 6 months and you haven't protected the deposit, each one of those new tenancies allows the tenant 3 times the deposit. So let's say they've been in there a good few years, you could end up with 9, 10, 12 times the deposit value as a claim.
And of course, the problem is if you didn't know to protect it properly in the first place, you won't know each time you just do a renewal that you're multiplying your problem until there's a bigger problem at the other end.
Absolutely.
And this doesn't have to be at the point of eviction. This could be at a point where suddenly the tenant realizes something.
Yeah, absolutely. So because this is a money claim, so it's a civil issue, the tenant actually has up to 6 years to come after a landlord for the failure of breach. So it could be that the tenant is still in occupation and realizes you haven't protected the deposit, so they can come after you. Or they can wait until they've vacated, leave it a couple of years, need a bit of extra cash for Christmas, and bingo, the landlord is the one they come after. So it is important to understand it's 6 years because I have had some cases, and I may talk about some case studies, where actually the tenant solicitor is actually trying to go after older tenancies that wouldn't really be able to be claimed against.
Yeah. So, I mean, your only bonus there would be is if you had the tenant, say, for example, for 10 years, and therefore technically 30 times, 3 times for each of those, assuming that you renewed the tenants on an annual basis, they could come after you for 30 times the deposit. And if that deposit was a nice, neat maths of 500, that's 15 grand. But if you then move forward, because they can only go back 6 years, small comfort, but instead of 10 years of, claims, it's 6, but it's still considerable, isn't it?
It's still painful.
Very, very painful, very painful. And then what about, because I know we had a conversation about this when we were meeting at the property educated, I find that so hard to say this sentence, the property educators accreditation scheme meeting
Yeah.
when we were there. And what happens if you are buying a property with an existing tenant, and that tenant, and we'll do two versions of this, that the tenant paid a deposit to the last landlord and it wasn't properly secured within either the prescribed information or within the time frame, and then you take over the tenancy with the existing deposit in the existing scheme because you don't know to check. You then start on day one with a new AST. You are then adding that liability to your own liability, aren't you?
Yeah, absolutely. So the key point to understand here is the wording in the legislation. Now, for those geeks out there, it's the Housing Act of 2004 and it's from 213 to 215. And what's really important is the fact that it says you only have to deposit when you have received it. That word is crucial.
Okay.
Absolutely crucial. If you've never received it, you can't protect it. You can't protect something you haven't got. So if the previous landlord didn't protect it and he hasn't passed it on to you, you can't protect it. You cannot be held liable. But your clock to protect it only starts the day you receive it.
Right. So so there's a piece of, I'm not going to call it semantics, but that bit about the previous landlord passing me the deposit. So if he, and you'd use a he. So if he gets the deposit back out of the deposit scheme that he hadn't protected it in properly first off, and then hands it via the solicitors at the point of purchase over to me, then I must take that, and we'll just keep the number as 500 quid. I must take that 500 and immediately proceed in the normal way. So I would create a new tenancy agreement. I would do the whole right to rent. I would do the whole prescribed information, and I would be responsible for securing that deposit. Is there a way that the first landlord, instead of physically taking it out of the deposit scheme, can just leave it in there and pass it over to me? So it gets passed over and I might not know about that?
Very unlikely. So all three of the deposit schemes are able to have the deposit transferred between internal accounts, so from one landlord to another. And that's usually only with the custodial deposit. So there's two ways of keeping deposit. Custodial is where you physically give the money to the deposit scheme and they hold it. And insured is when you keep the money in your bank account, but you let the deposit scheme know and it's registered as an insured rather than physically being held. Now, usually the custodial scheme, you can transfer it between deposit schemes internally. You would be notified of that because they would need to tell you the dates and give you the certificate and everything. So at minimal, you'll get an email from the deposit scheme, say the deposit's been moved over. So ultimately, all you've got to worry about then is just getting the certificate and the prescribed information over to the tenant within the correct time.
Okay. So again, I think I was going to say this only affects landlords that manage themselves, but it's not true, is it? Because if you've got a letting agent and they don't pay attention to all of this, you can be in trouble. So really, it's about education of the landlord. And number one way to get yourself out of this would be to secure it and give the prescribed information properly at the beginning. And then that's easy because you know that knowledge and you would never make a mistake on a property that you bought, let's say empty, and put a new tenant in. And if you know that information, then if you were to ever buy a property with a tenant in it, you're going to do a new contract anyway because it needs to have your name on it and your agreed rent, et cetera, you would then know to pay attention to this deposit. So there's no way that I, as the new landlord taking over a property with a tenant in it, can be liable for the mistakes of a past landlord.
No,
Okay.
100%. You cannot be liable for the landlord's past mistakes when it comes to deposit. You can be liable for past mistakes on other things like gas certificates and things like that. That will have an impact on you. But the deposit, absolutely not. So if the deposit wasn't protected or prescribed information wasn't given correctly by the previous landlord, tenant would need to go after the previous landlord because he breached. You didn't breach.
Unless you do mess up and you
Unless
breach
you
as well.
directly breach.
Okay. All right. Well, that's so that actually, I think if you summarize that as a piece of information, there is understanding there are two parts to this. One is the time scale involved, and at the moment it's 30 days, and it's believed that that won't change in the new Renters' Rights Bill when it comes out. And the other thing is the prescribed information, and the prescribed information is literally that. It's not what, as you said, it's not what we get to make up. It's a piece of paper that has got some very specific gaps that I guess you fill in, like names and stuff.
Yeah.
And then there is a certificate, because at the end of this tenant has handed over, no matter how much it is, and we're just using the number 500 quid, that's £500 of their money. They might have given it to me as a landlord as a security. You know, and it used to be called the security deposit, didn't it? If there was any damage to the property, if there was any rent arrears, this was your bit of security. 500 quid probably just covered 1 month's rent or maybe one room. It was no real, you know, it's not go away and have a party on it sort of money. But back in the day, this was money that would have been put straight into the landlord's cash flow. And then when the tenant left, if the landlord then didn't have the money to give them back the deposit, this was where you were getting all of these argumentative points where it was, oh, you've done this, you've done that, etc., etc.
Yeah, absolutely.
In order to avoid giving back the deposit. So this is money that is not ours, and that's why it needs to be secured. What do you think? Is there a better approach between the custodial or the insurer, or is it just a matter of choice?
I think it's just a matter of choice. I mean, personally, for me, I like to use the custodial because then basically the problem's out of my head. When it's in custodial, it's in custodial, no matter what happens. But with the insured will unprotect itself as soon as the fixed term ends. So you've got to remember to go back in and do some admin work.
Oh,
so custodial
okay.
for me is just, it's done. I haven't got to think about it again. Thanks very much.
Yes.
But the insured will uninsure itself at the end of the fixed term. I don't need the extra admin.
So if they roll over if they go onto a rolling tenancy, then technically if you haven't triggered it again, you are uninsured. Okay, so there's a real danger point, isn't there? And so you might have thought, because I same approach as you, I like the custodial, but there is a little bit of me that goes, you know, whether it's 500 quid or whatever the amount is, all of that money put away for a year, and if you've got a number of properties, all of that put away on deposit and you get a little 5% on it, why not? It's not like when the money goes in the custodial, the tenant gets their 500 quid back plus a rate of interest or anything like that. The interest, one would assume the custodial scheme has got the sense to put it somewhere where it's actually making money, but they're getting that profit on the top. So there's always a little bit, that queries this idea of insurance. But yeah, if you just came out of the tenancy and rolled on to fixed term, that's when you're going to start the problem again. And you'll have started the problem, even if you then rolled onto a fixed term for a month while you were catching up, or the tenancy happened while you were away on holiday and then you fix it when you come back and you give them a new AST, you're in trouble. And then that is 3 months for the whole of that tenancy until you create the new tenancy and do it again properly, because you'll have done it wrong day one. You need to then, even though you've now secured it, you've done it wrong. You can't undo doing it wrong. And you're going to carry that almost threat of 3 times fine coming forward, aren't you?
Yeah, absolutely. And this is where I probably enjoy this element of my job so much with these deposit claims, because we now have a sea of ambulance chasing, no win, no fee solicitors that have jumped on this bandwagon, because ultimately it's an easy win for them. If the landlord hasn't protected the deposit, there is no defence. You're banged to right. So they are out there sending the most horrendous threatening letters to landlords, demanding thousands of pounds, or we're going to go to court and we're going to win. Most of the time there's a few spelling mistakes and grammatically it's incorrect, so that always makes me chuckle. But these solicitors actually don't know the legislation as well as they could do. Now,
Mm.
it's a very small piece of legislation. Like I say, it is literally 213 to 215 of the Housing Act, and then an additional regulation, a secondary legislation, and then a myriad of case law. And it's the case law that I get excited about because it really does set the precedent. Now, most of the solicitors firms that I work with, they start off by getting it wrong straight from the beginning. 9 times out of 10, they never get the tenancy start dates right. And they will manifest a statutory periodic tenancy where one never existed. So when a fixed term comes to an end, two things happen. It will roll on to a periodic, but it will be a contractual periodic or a statutory periodic. Now, contractual is where you had in the original fixed term a continuation clause that said something like, this tenancy will continue month by month on the same terms thereafter, or something like that. So that means your continuation is a continuation of the fixed term. So if you protected the deposit, even in an insured, if you then forget to do the admin, you're safe because your contractual is a continuation. Now, when you don't have that continuation clause, you have what's called a statutory periodic, and that's where the fixed term comes to an end. It doesn't create a new tenancy, so the law has to take over. Statute has to say what happened. And a statutory periodic is a brand new tenancy in the eyes of the law, and this is where the breach would happen a second time when it rolled periodic. And this is what the solicitors are doing. They're inventing these statutory periodics to actually get another 3 times the value added to their claim when 9 times out of 10 they don't actually exist.
Wow. So at the very least, you might not be getting the landlord out of the penalty, but you could be reducing the penalty.
Yeah, absolutely. It's not my job to get the landlord off. If the
No,
landlord's breached, there's nothing I
that's
can
it.
do. My job then is to minimise what they've got to pay out.
Yeah.
A lot of the times I can actually get the claim quashed because the solicitors have just got it so wrong. One of my favourites was a landlord that came to me and he had a block of flats and there was 8 flats in this block that he owned. And he had obviously 8 ASTs in this block. And the solicitor wanted £35,000 in deposit claims for each of these tenancies where the deposit hadn't been protected. So I was like, oh, that's a lot of money. And the landlord was obviously, as you can imagine, quite at the end of his tether. But interestingly, all 8 ASTs were in the same tenant's name. Now, you know as well as I do, now, even if you have multiple personalities, you can't live in 8 properties at once. It's just not possible. So I was like, well, this doesn't add up. So at least one of these isn't going to be an AST, so there isn't a claim. I did a little bit of research, nothing more strenuous than, a company's house check. It turned out that the tenant was actually a rent-to-rent operator and an AST had just been issued in error. So I went back to the solicitor's firm and said, Section 1 of the Housing Act, you've got to be in occupation. She's not in occupation. Make your claim go away. And it did. But if the landlord hadn't come to me and had that question, he could well have paid that £35,000 or something similar in a claim that was never actually real.
But that was the rent-to-rent operator triggering that claim in that
Yes.
case.
Yeah. So basically, he'd ended the contract with her. She wasn't a happy chicken. And she'd gone
Right.
forward, well, I've got an AST. He didn't protect my deposit. Therefore, I've got this £35,000 claim. No, just because it's called an AST doesn't mean it is one.
Right. But would she even have paid a deposit?
Yeah, she
She
paid a
did,
deposit
because
as a
she was
rent-to-rent operator.
right.
So
Yes. Yes.
she'd paid it as her security.
Yes.
But of course, there's no legal requirement for him to protect that because it
A
should have been a
lease.
business-to-business
Yeah.
agreement.
Yeah.
There's no legal requirement. But yeah, she tried her luck. So did the solicitors, but they didn't get past me.
Nice. So that saved someone 35 grand. That's awesome. Have we got one more story like that? One more? You must have
Yeah,
hundreds, but
yeah, I do. Another one, again, it's always complex ones that the solicitors slip up on. So I had a gentleman come to me, and again, this was multiple tenancies. So I think the claim was bigger. I think it was 40,000 claim, £40,000 on multiple tenancies. Now, what had happened is the landlord that came to me had actually inherited the property on death of his father, who had been the original landlord. And he was now the landlord. He'd taken over the tenants and everything like that. Again, it comes back to that keyword receive. the original landlord, the deceased, his bank account had actually been frozen. That bank account held the deposits which had not been protected. My landlord, who'd come to me after receiving this letter from the solicitors, had never received that money because it was still frozen in the bank account. So we made that claim go away as well.
Oh, good. Good. But again, that's interesting, isn't it? Because if you are in the unfortunate position, really, of having a deceased family member leave you their property with a tenant in it, you've got to look at where that deposit is. So the number one job here. So if we put the two interviews together, so from speaking last week, it's about recognizing that you're a business. It's about making sure that before you take a tenant, that you are in a business mindset, that you do everything to protect yourself in terms of affordability and referencing and good customer service. But then you've also got to know the law. That's it. You've got
Absolutely.
to know the law. And
that
again, the
itself,
law is going to change, isn't it? So
yeah, absolutely. And the law itself is a minefield. There's currently 169 acts and 402 regulations that govern the private rented sector. And sadly, very few of those are fit for purpose, because one that I use quite regularly is an act from 1737, and that's when a tenant stays on after they've given their notice. So the tenant's given a notice to quit and then they don't leave, you can charge the tenant double rent, and you're relying on an act from the 1700s for that.
there's a little bit of me that says there must be some legal mind that could just sit there and go through this. And given that you can sprout things off, I don't know whether you've got cheat sheets down there or your mind is full
No,
of
it's all in here.
numbers. I know. And I don't know whether, I am absolutely in awe of your, rattling off pieces of legislation. But this is your expertise, isn't it? That you could just sit down and go, right, well, what are the things that we need to protect? And could you just not write maybe 100 laws or even 200, so we have one new act that does it, but that's not what the Renters' Rights Bill is going to do. It's going to fiddle and pitch and patch and,
Yeah.
We did also earlier on in this conversation, because I was saying to you about, so if you know the legislation, you're fine. If you protect the deposit, if you give the prescribed, easy peasy. If you don't, then there is this penalty of 3 years, but it's not passed back. It's not something that goes on. And then you slipped into the conversation, but the gas and the electric will get you. So do you just want to unpack those? So just tell us maybe what the rule is for gas and electric, and then how it can trip you up, and maybe a story there just while we're doing it.
Yeah, absolutely. So when you're taking over a property, where you're purchasing a property from another landlord and the tenant's already in situ, if the landlord hasn't done the gas certificate as they should have done annually and given them to the tenant, then ultimately you inherit that breach, even
Yeah.
though you didn't physically do it. Now, that will mean currently with Section 21, you won't be able to evict, because it requires a valid gas certificate for the term of the tenancy. And it also means that's historic, not just the immediate tenancy that the tenant is in. So it's really important when you're purchasing a property to add that to your tick list of due diligence, to see if landlord did the gas certificate prior to taking over the tenancy. Otherwise, you've been, again, it's a business decision. You're obviously not going to evict a good tenant on a Section 21 for the sake of it. Nobody does, despite what the government believes. You'll then have to be thinking, well, my only option now is going to be Section 8. Will I need to get the property back in the next couple of years? Is that part of my business strategy? But ultimately, when the Renters' Rights Bill comes in, we'll have Section 8 only anyway, so it won't have too much of an impact. However, we do know that the compliances that currently invalidate a Section 21 will be moved across and attached to Section 8. However, not for all of the grounds, only for some of the grounds. So that is a little bit more reassuring.
So that bit back then, if we just talk about a gas certificate, so at some point in the current tenancy for the current tenant, the landlord has not had a current gas certificate in one of those years, or maybe there was a gap or something.
Yeah.
You then take over that tenancy. In the new world that we think we're going to head into, you would only be able to evict based on a Section 8, which is typically rent arrears. Although I guess it must be your ability to sell your property as well at some point, but
Yeah.
rent arrears and selling your property. So you could still evict on that basis. But what was the term no fault eviction? You just decided you didn't want this tenant anymore. Maybe, for example, you're going to take your house and turn it into an HMO. That's a no fault reason, isn't it? So if you suddenly decided you want to do an HMO, but your tenant in its previous landlord's life had a missed gas cert, you wouldn't be able to evict.
Yeah, absolutely. Now, it is one of those things that judges' discretion, thankfully. And most judges are sensible, but there are a few that aren't, and will stick to the legislation literally, religiously. And where it says that there's a gap or the gas cert hasn't been done, they won't award the possession on the Section 21. So it's worth being aware of that. Like I say, it is judges' discretion, and a lot of the judges will allow it, especially if they've seen that there's a recent gas certificate, the property is perfectly fine, those sort of things. But yeah, it can trip you up, and I am aware of cases where the judges haven't allowed it at all.
So it might be a case that if you bought a property with a tenant in situ, and whether there was or wasn't a gas certificate and electrical certificate, if we lump the two in, you then renewed them, maybe some point between exchange and completion. So you know you're definitely going to buy it, and you get your gas and your electric engineers in there, and they create 2 new certificates. Excuse me. So at the point of completion, you currently do have valid certificates. Then even if there is a gap before, that might go in your favour.
Yeah, it's a might. Like I say, it's not a guarantee because it
guarantee.
is up to judge. But yeah, absolutely. The quicker you can show judge that you acted as the best landlord you could be, that always works better.
Yeah. But there are penalties, aren't there? There are financial penalties for not having a gas certificate in place as well.
Yeah, so not having a gas certificate, basically, it's a criminal offence. Unfortunately, it's not a civil one, and that's enforceable by the Health and Safety Executive. So they can, obviously, depending on the severity. I mean, if genuinely the property is safe, it's just a lack of gas inspection, then obviously the fine and the implications are going to be minimal because there's no threat to life. But if you've not got a gas certificate in place, someone comes around and does an inspection and finds that the property is dangerous, that's going to carry something much more extreme. Health and Safety Executives have unlimited fining powers, and they can also commit you to 6 months in prison or more, especially if somebody sadly passes away, and that would be then corporate manslaughter.
Yes. Because, I mean, that's the point of all of this, isn't it? So, if we round it all up, from the previous podcast, if your tenant is in financial difficulty, this is about mental health and humanity combined with a business. And so it's your business, but at the same time, you're in a business to customer, business to human business. Be human yourself, but at the same time, if you put all the checks and balances in place and you know what's available. So I will put the link at the bottom of this in the show notes to take you back to last week if you didn't get a chance to listen to it. And then if we move forward and you're following all the legislation, then you shouldn't be in a position where you've got a problem with deposits or gas certificates or anything else, because you should do it properly. But if you don't, then thanks to Julie, you now understand what the consequences are. And I think maybe last week we were talking really about customer service and being a better business, being a better landlord. Yeah, maybe that's what it was. Last week was being a better landlord. This week is about being a professional landlord, because now you've got to know, the legislation and you've got to act. Would you say that's how we do the bit between the two?
Yeah, absolutely. I think, definitely.
Yeah, be a better and be professional. That's good. And quite frankly, that's what we all need to be anyway. I mean, if for nothing else, then just lately, I don't know about you, but when I've watched TV programs, whether they're comedies or murder, death, kills, the bad person is always a landlord or a property investor or a property developer. We're the new crims and the person to hate, even in TV programs. Never mind what the government is kicking out.
Yeah, it used to be that in all American films, the baddie was always English. The English accent was the criminal. But now I think you're right. It's the property developer that is the criminal.
Yeah, and we're all just lumped in. And really, it's such a shame because we're the one that have been providing the housing for, I would say pretty much the last 20 years. My 20 years in this, and when I started back in 2004, there was a shortage of houses. And there has not been, that's not English, but it has not been a shortage of houses since. I think you said, was it the last interview, was there like 21 people per vacant house? We've seen
Yeah,
pictures of people queuing up, and yet why not a professional landlord? Now, I'm quite happy to knock all the bad landlords, and theoretically they've brought in licensing that is supposed to solve this problem, but it doesn't. It just makes money for the local council, and there are still beds in sheds, and there are still bad landlords, and TV, Channel 5 can still make its programs scum landlords and all that sort of stuff, can't they? But I think it's our duty to be professional and change the conversation. I think that's what gets me cross. That, and you mentioned it too, that ridiculous statement by Keir Starmer just before the budget about working people. And I think it was really started by the journalist. I can't remember what her name is, the dark-haired woman off of Sky. She lumped stocks or shares and assets, shares and property together. She put the two words in a sentence. And, if you've got shares, I don't think you do have to work on shares because you usually buy them through a scheme and you're paying someone to pick the shares for you. That's what most people do. Although don't knock people with shares because that's everybody who's got a pension, because all pensions are in shares. But to turn around and say that we don't work, I think if anything, these two podcasts, if you take them back to back, the level of education we have, the responsibility is on us, that whether you are still self-managing some few properties in your personal name or whether you've got a small, medium or large portfolio in a limited company, you are working. You said one sentence, which was, landlords are the only people that are taking calls at 10 o'clock on a Sunday evening because a light bulb doesn't work.
Yeah.
That's working people. Frankly, that is someone who hasn't managed their tenant, as far as I'm concerned.
Well, yeah, there is that.
Well, Julie, I just want to thank you so much for spending the time with me and for being kind enough that after we did just one podcast to actually stay around so that we can record this week's, because I just knew there was a lot more to get into. And, this has made yet a whole nother podcast. So I'm very, very grateful for your time. I will put all of Julie's contact details in the bottom of both podcasts. And I absolutely hope in the most lovely way for you, the listener, that you never need Julie. But obviously,
Absolutely.
if you ever do need Julie or you ever do need help, Julie is the one to go to. And I know that once we actually get the final versions of the renters' rights, I'm sure you'll be putting out loads of very valuable information and helping people get up to speed, providing that education that we very definitely need. So for now, thank you very much. And
Thank you very much.
I look forward to speaking to you again soon and seeing you soon.
Thank you.
Thank you very much for listening. I hope that you found that as educational, informative, and possibly even a little bit shocking, if necessary, to get you to take action. As you know, I've been in the business for 20 years, Julie, similar, and there is plenty of education opportunities out there for you to take. You'll have noticed the link. I am revising, as I said last week, my online course, where you will also not only be able to learn at your own pace with educational materials created by me, a former university lecturer, so I know how to create materials to enable your learning, whatever your preferred style. So if you're interested in learning more and really getting clued up on how to be both a better property business owner and a more professional landlord, then there's a link there where you can just go, I'm slightly interested in this. I'm not committing to anything, but I'd like to know more. Keep me informed. And if you click on that link, and it'll be in the show notes, then we'll send you more information as we redevelop the course over the next few weeks, few months. Take very good care, and I will speak to you next week when we have got the first of 2 very special episodes where I am going to be going back over the last 150 recordings and picking out the highlights for you on first mindset, and then how you can be more in control of your finances and financial resilience. And I thought that would be a great thing to do over the Christmas period, because I can then point you to the best podcast for you to listen in those points where you've had enough of watching reruns on the TV. So make sure that you've subscribed, and I will speak to you again next week. Take care.